Now call the first case on this morning's docket. That is case number 112316, State of Kansas v. Wynn.
May it please the court, Joanna Labastida of the Appellate Defender Office on behalf of the defendant Ebony Wynn. If I may, I'd like to request 3 minutes rebuttal.
3 minutes is granted.
Thank you. Ms. Wynn entered a no contest plea to 1 count of felony murder, and prior to sentencing, she requested a durational departure. The sole issue in the brief is that the district court abused its discretion when it denied Ms. Wynn's motion for a durational departure. Our argument is that under KSA 216806, subsection C, a durational departure is not prohibited. The statute specifically prohibits dispositional departures. We'd argue, therefore, that the district court erred when it believed it did not have discretion to depart. The state's argument...
Is that all you have to show, is that there's no prohibition? Haven't we said that sentencing is entirely statutory, which would mean you'd have to show where it was authorized?
Well, I would argue that this might have just been perhaps a mistake by the legislature not to specifically authorize or prohibit, but with the way the statute reads now, it is not specifically prohibited.
But is it specifically authorized?
Not so far as I could tell from the reading of the sentencing statutes.
Because the departure statute that talks about departure speaks of grid box or grid sentences, and this is off grid.
Correct. But the subsection that discusses 216806 subsection C, that does say it's off grid and a life sentence, it does not include a specific statute that mandates no 216623 is missing from that when it includes other subsections that would alter that statute. And that one specifically says that it's not eligible for probation or suspension, modification, or reduction of sentence. And that specific statute is left out of 216806 subsection C. And so we would argue, because the legislature did not include that statute in with the felony murder statute, then durational departures would be allowed, at least to request that durational departure and have the district court consider it.
And what would be the mechanism if there's no statute that authorizes? What would be the process, procedure, or mechanism? Would you just have to use another one by analogy, or?
Well, I would, to give guidance to the district court, probably yes. But I would argue that 216806 subsection C, because it specifically prohibits the dispositional departures, durational departures would just go as they normally do with the departure statute then coming into play. 6817, I think, is the...
But doesn't the statute pretty clearly indicate that it is a life sentence? So by dispositional departure, the legislature could be indicating you have a life sentence and we're not going to let you serve that sentence in any fashion other than prison. Is there anything in the statute, that you would say argues against any legislative indication that there is any tolerance for anything less than a life sentence?
Again, my argument would be that because it says except as otherwise provided by, and then a whole host of statutes, it's clearly missing 216623, which specifically says that no modification or reduction of sentence is allowed for certain sentences, including...
But is that necessary if the statute is otherwise clear that it is a life sentence?
Ms. Wynn's argument below was that because it does not specifically prohibit a durational departure, then she could at least request one to the district court. And that would conclude my remarks on this topic.
Did you have anything to talk about on what I understood was your default provision or default argument, and that is that there was reason to depart?
Oh, yes, Your Honor. The district court did say even if there was authorization for departure, that it would not grant one because of a whole host of reasons. We would argue that there were reasons for the departure, substantial and compelling, such as her lack of criminal history, her role in the crime was less than others, her co-defendants, and without having that ability for the district court to depart in front of it, we can't know for certain whether or not the judge would have departed. And so we would argue that he abused his discretion both in not exercising that discretion and also because there were substantial and compelling reasons for that departure.
Well, I thought he made it pretty clear and said he would be unable to find substantial and compelling reasons to depart because Ms. Nguyen was the driving force behind the shooting.
That is correct. He did make that statement at sentencing. The only thing I can say is that he might have changed his mind if he believed that this court would allow for a durational departure, and we can't know that, for certain without a remand.
And what would be our standard of review on that question?
It would be an abuse of discretion as well.
With the prong being no reasonable person would agree?
Yes, sir.
Is that?
All right. Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Boyd Isherwood on behalf of the state of Kansas. As counsel has indicated, there is one issue before the court today, and that's the district court's refusal to grant a departure sentence on a felony murder count. As with the district court judge, the state's position is that there was no authority to depart. I believe Justice Johnson is correct when he indicates that the starting point is authorization. Without authorization, it's not an option. Sentencing in Kansas, as I understand it, is entirely statutory. I do think that the provision at hand speaks to both durational and dispositional by indicating first that it shall be life, and second, that there is no chance of probation. So it clearly speaks to both, prohibits both. I suppose it could have used a different language, but I don't think that in the event that you find the need to do some sort of interpretation or statutory interpretation on the matter, that there's anything in the statute or any other statute that would indicate that it was the legislature's intent to provide for departures for felony murder. Shifting to the alternative argument, as the district court did make a finding, perhaps seeing into the future, that in the event that his analysis on the statutory provisions were in error, that there is no way that there were substantial and compelling factors presented for a departure, and the district court's foundation for that was that you simply cannot be the ringleader in a plot to take another human's life and then ask for a departure. I think that's a pretty sound decision, and especially one that a reasonable person would make. Unless the court has any questions, I would respectfully request that the district court be affirmed.
Counsel, are there some other statutes that would be negatively analogous to 6806C? In other words, where the legislature has said this is the mandatory sentence, but you can depart for certain reasons?
I think I'm tracking the question. One extremely similar situation where the legislature has expressly provided for departures is the Jessica's Law. It falls under the same statutory provision, but then indicates, when you go into the Jessica's Law statute, it indicates a departure to the greatest possible under certain circumstances. So in the event that statutory interpretation would be needed, and the state's position is that simply no interpretation is needed, but in the event that interpretation would be needed, the fact that in other off-grid crimes, the legislature has provided a separate provision for departure would indicate that they did not intend to do so here.
All right, thank you. Any more questions of council? Thank you, council.
Thank you.
You reserve 3 minutes for rebuttal.
Yes, Your Honor. At this time, I'd like to waive rebuttal unless there's questions from the court.
I see none. Thank you.
Thank you.
We thank both of you for your arguments this morning. Court will take this matter under advisement.